Ready? Oh, okay. There was an amendment to the indictment. Change to run. One of them said,
Do you want me to email? I'm just going on council now too.
thank you. Good morning, sir. Are you Floyd Torrin?
Yes, ma'am. Good morning.
And Mr. Radford, will your client waive the formal reading of the indictment in each case?
Yes, ma'am. He will.
Mr. Torrin, in clause number 25 DCCR 0794, you're charged with a third-degree felony offense of attempt to commit theft or property from an ATM, and that's from May 10th of 2025. The indictment alleges in count 2 that you were convicted of the felony of possession of a controlled substance, a second-degree felony, August 16th of 1999. How do you plead to that charge?
Guilty.
And is that prior conviction true? Did you enter your pleas of guilty and freely and voluntarily?
That single word right there changes everything. Guilty. In court, that's not just an answer. It's a legal turning point. Once a defendant admits guilt, the judge isn't guessing anymore. She's sensing reality. The question now isn't what happened. It's how much time it will cost.
Voluntarily. And did you plead guilty because you actually did what they charged you with? All right, give me just a second and I'll get that. The efficiency of going. All right, then, Mr. Torrin, in cause number 25 DCCR 1152, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. The indictment alleges the same prior conviction of possession of a controlled substance in count 2. And how do you plead to that charge?
Guilty.
And again, is that prior conviction true? Did you enter your plea of guilty and true in this case freely and voluntarily, and because you did what they've charged you with? Each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of these cases is that, the agreement was that the state allowed you to plead only on counts 1 and 2. And that your punishment is the full range of punishment, which is a second-degree felony between 2 years and up to 20 years up to the court. Knowing that had you gone on the full indictment, you would be looking at a habitual status, which is 25 to life. Is that your understanding of your agreement?
Yes.
I want to make sure you understand you have every right to have a jury come in and determine 2 things. One, if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving it up to me, and also waiving your right to appeal as long as I stay within that 2 to 20 range. Do you understand? And is that what you want to do?
Yes, ma'am.
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Mr. Torrin is not competent?
No, ma'am.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Also find that you entered those pleas of true to counts 2 freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Radford, and he'll get it to me so that I can review, and he'll present more whatever that day when we come back for sentencing. All right.
Judge, I'm gonna have some documents I will present.
Thank you.
I'll
Thank you.
email them to the clerk and CC Mr. Smith.
Okay, make sure you get them to probation and they'll attach them with the PSI as well.
Yes, ma'am.
All right, thank you. You can go back with the bailiff.
May I be excused?
Yes, sir.
Right. There was just individual land being, I didn't even know it's within the statute. Period.
Good morning. Are you Brenda Sanchez?
Yes, ma'am.
This is clause numbers 26 DCCR 0027. And then Ms. Sanchez, that's a new case of a possession of a controlled substance. And then Ms. Sanchez is on probation and clause numbers 20-33832 and 20-33, I'm sorry, 20-34508, both of those for theft of property cases.
Yes, ma'am.
And so what are we here for today?
Well, Your Honor, we would request a hearing on the MTRP for them to try to prove up the new case. I think she's performed satisfactory as far as administrative.
So there's no agreement with,
This is where the courtroom tension really sharpens. A probation hearing sound procedural, until you realize it's basically a legal tightrope. One wrong true can unravel years of freedom. And notice how every answer is now carefully boxed into true or not true. There's no storytelling in court, only consequences.
just need to go through the motions.
Well, yes, ma'am.
Okay. Ms. Sanchez, lift the hand, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will she waive the formal reading of the motions in each of the cases?
So,
Ms. Sanchez, in clause number 20-33832, I have a motion to revoke your community supervision. Shows that you were placed on probation February 22nd of 2021 for the offense of felony theft that had been enhanced to a third-degree felony, and that was a 10-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Just a second. All right, I'm there. And then in clause number 20-34508, I also have a motion to revoke your community supervision. It shows that you were placed on probation February 22nd of 2021 for the state jail felony offense of felony theft that was enhanced to a third degree. That was also a 10-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count 1 in each motion alleges that you committed the new offense of possession of a controlled substance, penalty group 1, in an amount of between 4 grams and up to 200 grams, August 15th of 2024 in Jefferson County, Texas. And is that true or not true?
No, ma'am.
True or not true?
Well,
I just need you to
not
say the
true,
word, true or not true.
Not true.
Thank you.
Sorry.
And then count 2 alleges in each case that you failed to avoid persons or places.
And there it is, the moment everything tilts. One true admission in a revocation hearing is often all the state needs. It doesn't matter how many charges are denied, just one confirmed violation can tip the entire case toward revocation. The real question now, is this a warning shot or the beginning of the end of probation?
Of disreputable or harmful character, specifically by failing to avoid presence at a location where a criminal act was being committed, by residing at a location identified by the Beaumont Police Department as a narcotics stash and distribution location. And is that true or not true?
Not true.
Count 3 in each case alleges that you possessed a controlled substance, namely Dilaudid or hydromorphone, without a prescription, August 15th of 2024. And is that true or not true?
True.
And just like Thathis's case flips, even though she's still arguing parts of it, one true admission is enough to seriously damage a probation case. That's how revocation hearings work. It doesn't take everything being proven, just one solid violation. The real tension is building, will this turn into a full probation revocation or a second chance after the hearing in the RVE?
That is true.
Well, I mean, I'm in possession of it was my friend's medication that was at my house.
Okay.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Not true.
All right, so I'm going to show that you entered a plea of true to count 3. Did you plead true to count 3 freely and voluntarily?
Yes.
Okay, so I'm going to find that count true, find sufficient evidence to revoke your probation. However, I'm going to reset your case so that the probation department can do an updated report. We'll get it set for a hearing. The state intends to bring witnesses with regard to the new offense.
Yes, Judge, yes. Should take there a minute, and it shouldn't take very long. I know, on the heels of yesterday.
I'm a little gun shy on that,
After
Mr.
yesterday.
Coleman. We'll set it, an 11 o'clock hearing shh, I'm talking, Mr. Kimler. So I'll set it at an 11 o'clock hearing, and here's the important thing, Mr. Kimler, as we've talked about before. If there's something that comes up and there's some change in status of her pleading true or not true without the necessity of a hearing, please let Mr. Coleman know that. I don't want officers showing up here and wasting their time, and then all of a sudden there's a deal made at the last minute, okay?
To speak that, Your Honor, but I do think that as far as possession goes, I understand the circumstances that she's explained them to me. I don't want any kind of perception by the court that she's misrepresenting things, but it may be better that I change that to not true
Yes, sir.
on 3.
So there'll be,
There's
please
an
and not true, it's all right, we'll
there's
get to
an
that.
explanation for that.
Please and not true on all of the counts. State will bring witnesses on those, and we'll get it set for a hearing. We'll get an updated pre-sentence report. Obviously, Ms. Sanchez, anything that you think is important for me to know, get that information to Mr. Kimler. He'll present it to me on your behalf when we come for the hearing. You can go back with the bail. Oh, wait, we need a fingerprint.